I'll be here.
Yes.
Hello, hello, hello. Testing 1, 2, 3.
Yeah. But if anything, like I remember I was talking Where are you? You know that if anything like the executive period, for sure, at least 3 weeks or oh, that's one of the biggest part. A week on. I still need to watch the. Yeah. I thought we were.
I think it's supposed to be what the names you put there were yeah, somebody.
I mean, there's a lot, but there's still not as much. Like I gotta start with
literally
the branch.
Yeah, so 6, 1, 6, 6, 13.
Hi, Haley, what's up?
Yeah, I'm flying there. Universal. Yes,
Yeah, I have to. I think everyone's here. All right, you're quiet. Good, I'll start. So you have a treat. See me again on Sunday. Not really. I will be not in this room, but room 316. This room is actually occupied. They have some sort of moot court or some other competition, but room 316. I prefer you come in person. If you can't, Zoom is an option. I will be running attendance. Okay. Hello. All right. Questions before we get started. All right. Let's start with a question. Short answer. So you do with this one. What does it mean for a law to be arbitrary? One sentence. What does it mean for law to be arbitrary? And try not to use an adjective like unreasonable. I know. I'm sorry, Anna. I know what you're gonna write. Try to actually, so I'll give you a rule of thumb. I try not to use adjectives. Describe things with nouns. You'll be a much better writer. Adjectives are for lazy people. True. Best writers don't use adjectives. Adverbs are even worse. Don't use adverbs ever. Just use nouns. Good advice. I try very hard not to use adjectives. No, I actually woke around 6 this morning. I think I'm good. Yeah, I think I'm actually back to normal. Took a couple of days, but I'm okay now. Yeah, Monday night I was falling asleep. My kids were like bath time. They wake. I went to sleep when they did. All right. Another 15 seconds. And who am I up to? Where am I in the roll? Oh, perfect. Okay, good. Stephen, how would you define arbitrary?
Means that must give a reason for it. That means based on your will rather than reason.
Okay. What's reason?
Like based on will rather like you must give a rational basis for what you do.
What does rational mean?
That you're limited by a substantive due process.
I'm not talking about law. I'm saying just arbitrary in general. What you said rational. What does rational mean?
That's you have to have basis, rational basis, and some reason for what you do.
About back to reason. So what's a reason?
Like a rationale for why you do something.
Will any rationale do? Can I just make one up?
Yeah. Asked,
If I give you a reason, that's not my will. I'm giving you a reason. If I say police power, that's it. It's health, safety, and welfare. That's why this law exists. That's my answer. Police power. Is signing the police power necessarily make the law rational?
you have to give people, it's limited by the due process. Police power.
All right. What do you think?
It's like imposing your will as opposed to.
But isn't every exercise of government power an exercise of
Yeah, but some of them
will?
like some of them there will be a real issue that a law can solve by imposing their will. I guess this is kind of like it's very clear. This is from I'm thinking of the laundromats, but like it's very clear that.
Very clear to who? Yeah, but very, very clear to who, though? It's the judges or the legislature? See, oh, you. Who are you? Who made you God, right? Who made Supreme Court God? Galen, what's your answer, sir? What is arbitrary?
I'd say without justification.
Okay, without any justification or good enough justification?
Without good enough.
Okay, who gets to decide what good enough is? Says who? Who gave him that power? And Trent, I'll come to you with a follow-up. How can a court decide whether a justification is good enough? Okay, but how do you know if the rationale given is good enough? You look at the intent, all right, but how do you know? Do they have to decide at some point? Maybe the buck doesn't stop with the court. Maybe the buck stops with the legislature. Steven, you want to add something?
Well, it's what they were doing in these cases was just their means as their.
Well, I promise you are giving me the right answer. I'm not ready for the intent yet. I promise. I'll get back there later. I'm just asking what arbitrary is. We're talking about this word. It comes up in a lot of news. Zoe, hello. I think you're next. Zoe, how do you define arbitrary? Oh, you did the thing I said don't do. I said don't say reasonable. You said rational instead. Okay. But how do you know what a rational basis is?
Else would.
So it's like torts, like a reasonable person standard, something like that. Abdullah, let me ask you a question, please. How is a judge sitting in his office in Washington, D.C. supposed to know what reasonable people think? My goodness, they are cloistered, they're hidden away from the real world. They are not, they live on a planet of their own. Oh, so their experiences before they became a judge, maybe?
That and while they're sitting on the bench.
So judges should be issuing rulings based on their own personal feelings?
Not their personal feelings, but I think it gives them a background.
Isn't that their will, not their reason? Is that the same thing with, we're saying you're not supposed to rule based on your will, and how does a judge know if the rule is reasonable, rational? These are not easy questions. I'm not asking you light questions. These are actually very fundamental questions. You'll see case after case, the court says, this law is arbitrary, this law is reasonable, this law is rational, and they'll give all these sort of adjectives. But I don't like adjectives. They don't actually tell you much. In fact, most of the time, adjectives hide the fact that you have no real, no, you know what you're doing, right? It's like, of course, this law is reasonable. Why? Like, you ever have a kid says, why, daddy? Why? That's like a million whys. That's what I do. Why? And you get like 3 or 4 whys. Like, I don't even know. I have no idea what I'm doing. Right? You don't know why anything works. You have no idea. You know, like, how do you know, members ask, how do you make toilet paper? Okay, eventually I don't know. Right? There's an answer somewhere. I don't know how to do it. Okay. So this first question, I'm looking at sort of this word cloud, and I put reason. And that's all well and good, but we don't all reason in the same fashion, right? The way I approach a problem is different than the way you approach and the way you approach it. That's fine. We're all human. We're all wired differently. To Abdullah's point, he made a fair point. Everyone who becomes a judge brings with them, you know, certain experiences. It's not possible to become a judge as like a blank slate, right? You're not like just creative clay as a judge. You have your own experiences and you've seen things. Now, this is not to say that it's partisan, that, you know, the Republican or Democrat, there's what we call judicial philosophy. Judges have philosophies. They think, you know, for example, in the current court, you know, Justice Gorsuch really doesn't like government. He's just very skeptical of the government. He just doesn't trust me. There are books about it, though. He hates the government, right? You know, Chief Justice Roberts, he likes the government. He's part of it. He's in there, right? That's him. He is the state, right? Every justice have their own sort of personalities and what they think are important. And that's what comes through in their opinions. But don't pretend for a minute that when a judge said this is arbitrary versus is reasonable, that's like some sort of a bright line test. Even look at Lochner, 5-4. And you have very different conceptions of how the law works. All right. I guess a harder question. Do I have it here? Now let's do it anyway. Hi. What's liberty? Sorry. That's right in the text right there. What does liberty mean? Freedom from what? Oppression by whom? Anyone. Well, there seems to be a tension there, right? Can you both be free from the government and free from private parties at the same time? Isn't it the case that the government protects you from harm? And can the government cause harm? So what is liberty? So I gave this analogy last week, but I'll give it again. I didn't make this up. This is actually from Abraham Lincoln, who I think is a good person to sort of quote. Lincoln said, "We all declare for liberty, but in using the same word, we not mean the same thing." Good quote, right? Yeah, we don't all mean the same thing. So I think what you said was I think a good statement, right? Liberty might mean freedom from the government. But one might say, well, what's the point of being free if I can be murdered tomorrow by someone? Liberty might also mean protection and security from the government. Neither position is right or wrong, right? These are just different conceptions. Lincoln had this great metaphor. He didn't make this up, but it's often attributed to him. He says, the shepherd drives the wolf from the sheep's throat. The sheep sees the shepherd as a liberator, right? The sheep sees the shepherd for protecting him from this carnivore. What about the wolf? The wolf is hungry. He needs to eat some sheep. And the shepherd is his oppressor, destroying his freedom to hunt as he wishes. So the very same act of the shepherd protecting the sheep from the wolf is both a liberator and a tormentor. Is that kind of profound? Just think about that for a minute, right? So there is no one conception of liberty. Even on the court, I'll use an example from the Obamacare case. This came up. The lawyer for the Obama administration argued that the healthcare law actually promotes liberty. Huh? And he said, liberty means the freedom from fear. And if you're worried where your next, chemotherapy treatment is going to come from, right? Where your next medicine is going to come from, that's a fear. And this law, at least in theory, will provide people with the health security they need to exist. That's a belief. People believe that, right? And then the other lawyer came up, Paul Clementi, said, it's a very funny conception of liberty that we become free by being made to buy a commercial product, by being able to buy insurance. And that's just a very different conception of liberty. I mean, you could say one's right when the other's wrong, or both right, maybe. But we shouldn't pretend that there's some sort of clear definition of liberty. How are we doing here? Am I making you woo-woo yet or not? Not yet. Yeah, and ready for this one? What does the due process of law mean? Due process of law. Sorry, he's laughing. Oh, you'll be next eventually. Is it only about trials? What more does it mean? Without? Okay, so what's due process of law? That's my question. Laura, let me focus on the last two words. Right, we have due process of law, right? What's law? I'm gonna be fun now.
Regulations,
Regulations, my goodness, what does that mean?
restrictions.
What is law? Where does law come from? Why do we law? I don't know, I'm fine, right? What ideas, sure, I'm fine, Laura.
They're supposed to be a reflection of what we want our society to look
Who's
like.
we? You said we.
The people,
The people. Where does law come from?
our agents,
Who are agents? Who are agents?
Congress,
Congress. And where does Congress get their power from?
Constitution.
And where does the Constitution get its power from? Ooh, good. All right, that's good, good. So I think I asked a variant this question the first week of class, right? Why do we call it court rulings, right? But the idea of due process, it's not just procedures, it's due process of law. And one of the fundamental innovations, like sort of Western civilization, is that there's law. That there's some power above whoever's in control, the king, the president, the Congress, whatever body you want to have, that there's something that's greater than individual will or whatever's on your mind at the time. That when the government takes an action against you, it's based on some law. There's some process that is due under the law. Oh, right. There's some procedures that are due, but it's not just procedures, right? It's the law itself must be consistent with the due process of the law, that the law is within the bounds of power, the enumerated powers, if you will, of the government. And the 14th Amendment imposes more restrictions on the states. Is this law within the powers of the state? Is it police power, or does it go beyond? But deciding whether a law is consistent with due process, that's not something that's easy to do, right? There's no actual clear test for this. And for at least since Dred Scott, and maybe even earlier, there have been debates about what due process of law requires. And we have a lot of cases today that seem to go back and forth and maybe don't quite make a lot of sense. All right. Did they weird you out yet or not yet? Yeah, yeah. All right. It's deep stuff, I promise you. It's a little deep, but I think it makes a lot of sense because you'll read, I'm sure you buy you buy porn books, you're wasting your money. But what does rational basis mean? Rationally related to, promote this and that. No one knows what those things mean. No one knows what rational basis means. Now you guys know, right? What rationality means. It's truly what a judge thinks sort of makes sense. But that's not any kind of clear, bright line test. All right. I did the lottery last week with the stoning, so I don't need to do that one again. The police power. So again, we've spoken of the police power. It's the power of the state to regulate the health, safety, welfare, and perhaps morals of the people. Where does this police power come from? If it comes from anywhere, it comes from the fact that we had a government before us, right? We had a king, we had a monarchy, we declared independence, and whatever powers that the monarch had devolved to these new states. Now, the states have all the same powers the king had. The states have relinquished some of these powers. You don't have a king, for example. But the police power, to the extent it exists, came from before our country. That the very basic reason why we have a government is to protect the people, protect their health, protect their safety, make sure they're not being harmed, they're not being injured. But throughout the 19th century, this conception of the police power expanded, right? Believe it or not, the idea of a police force, right, with police officers, that did not really exist at the time of the framing. There were not police departments, right? There might be marshals and people perhaps to issue court orders, but there weren't like police we could call. I mean, there were no phones. And another facet of the police power expanded as well. Safety regulations, right? There were no food safety regulations when the Constitution was drafted, right? They didn't have restrictions on how food we prepared. It wasn't even known what bacteria was. We didn't even know what those things were. But throughout the 19th century, people started being worried about sanitation. We also have the rise of industrialization, right? People used to work on farms, but factories developed. And with factories developed, people started moving into cities. They were very cramped. Wasn't a lot of sunlight. Wasn't a lot of fresh air. And people started seeing this relationship between having these poor conditions and unhealthy food and sickness. This was all part of what was known as the progressive era. The progressive era. That means a lot of things to a lot of people. But at least for our purposes, the idea of the progressive era was using the power of government to promote people's welfare. Whether that was a food safety law, whether that was a regulation on hours, regulation on wages, a regulation on unions and organized labor. All these sort of ideas start coming around in the late 1800s and into the 1900s that government could come in and sort of protect people's interests. So even when we talk about the police power, there was not a fixed conception. It was something that truly expanded by leaps and bounds throughout the 1800s to 1900s. Slaughterhouse was one such case, right? Slaughterhouse said, if you want to slaughter animals, you must do it at the central butchery, central slaughterhouse. And at least that was a 5-4 decision. And the other said, no, you have the right to slaughter wherever you damn well please. It's not up to the government to decide this. By the time you get to Lochner, and we'll talk a lot about Lochner this semester. By the time you get to Lochner in 1905, you sort of have these two currents on the court. The one current might be called broadly pro-business, well, that's not exactly accurate. The one current is saying that people should have the right to contract and make the business arrangements they wish. And there was actually the due process clause of the 14th Amendment, not privileged immunities. It was a due process clause of the 14th Amendment that protects this liberty or this property interest. The second current is what might be called the progressive view. The idea was it should not be the courts who decide whether these laws are reasonable. The court should not decide these laws are rational. If the legislature decides there's enough reason for this law, that's good enough. That's deferential. That's not dissimilar to what happened in Plessy. Right? Again, I don't want you to separate them precisely, but just think of them in different categories. One says we should closely scrutinize government laws to decide if they're reasonable or not. Is the reason they're giving the real reason? Think of Yik Wo, right? It's the evil eye and the uneven hand. Or will this be a matter of deference, like in the Plessy case, where it's not for us to decide why they're separating the train cars? Today we might think, of course, there's a difference between economic regulation on wages and a segregation law about train cars, but that distinction is really one of modern case law. Back in the early 1900s, there was really no difference. A regulation of trains, a regulation of bakeries, it's the same thing. Can the government use the police power to control how institutions, how businesses arrange themselves? Telling how many hours someone can work versus telling them where they have to see customers. Those are viewed in the same sort of genre. All right, they're with me. Okay. So Lochner is probably one of the most controversial cases in American history. Huh? How could that be? So Addie, if I could just ask, when you did con law last year, what did you know about Lochner?
Well, I would say we learned that probably it was much better to have these bakery regulations for the people because they needed this. And why would we be second guessing the legislature that's there to protect them?
So it was described as a bad decision. Really bad, right?
Yeah.
So people, I'm not exaggerating, law professors, my beloved colleagues, will hold Lochner in the same sentence as Dred Scott and Korematsu. Truly, I'm not making this up. If you ask people to list like the 5 worst Supreme Court cases ever, they'll probably say, okay, Dred Scott, Korematsu, Lochner, maybe Buck v. Bell, maybe 1 or 2 others. And think, wait a minute, Josh, how could this case have become so awful to compare it to Dred Scott upholding, slavery under the Constitution, or Korematsu upholding racial internment? This case doesn't seem that bad. Is it that bad? So I will admit my biases on the table, and I always try to be candid. I'm an outlier, many ways more than one. But I was raised in the school thought that this was actually not that bad of a case, and maybe it's even correctly decided. I ultimately think it's probably not, but we'll explain why in a moment. But the reason why Lochner became so vilified had nothing to do with bakeries. It had to do with a clash between progressives and the Supreme Court. And Lochner became kind of like the token or the icon of the way you should not be a judge. And it's only years later, it's actually Theodore Roosevelt, who was running for president, held up Lochner as this awful decision that needs to be repudiated, and became much more pronounced during the New Deal. Now, we've already studied the New Deal in the context of federal power, right? And Laura Beavers Jones and Laughlin Steele, Wicker v. Filburn, these other cases. these cases sort of recognize that the court should not be second guessing Congress. Lochner was the parallel, that the court should not be second guessing the state legislatures. So for the same reason that the Roosevelt administration hated federal limits on power, the progressives hated federal limits on state power. So you can't really get Lochner to understand the broader context of what came later. Lochner wasn't controversial at the time. It only became much more unpopular later. The related part is that my professor, David Bernstein, my law professor, wrote a book called Rehabilitating Lochner, bringing Lochner back. I think he succeeded in large part. But to this day, you will see judges like recoil at Lochner. Like Chief Justice Roberts looks at Lochner as no different than Dred Scott. He does. He says it very clearly in his gay marriage dissent.
This thing on Lochner.
Good. He wrote that when I was a student. Oh, it's a good story. It's a very good story. All right. So let's actually walk through the facts of Lochner. I did that route. Oh, Karen, I think you're next. Yeah. Karen, the facts aren't too complicated, I don't think. Give me the facts on Lochner, please.
Basically, there was an employer who wanted to challenge the maximum hours that an employee can work per week.
All right, so I'm gonna blow your minds if I can. So, how do I put this? Why are there laws limiting how many hours people can work? Brett, why are there laws limiting how many hours that people can work?
Won't be, but also too, I think it's like the right thing to do, you know, like, I would hate personally to be like on the clock 24/7, so like to have that grace period, so like, oh, I can go home after 18 hours.
Isn't it nice to have that luxury not to have to work so hard? Ryan, what if you're a poor immigrant? And these were mostly bakers or immigrants, and you needed those hours. How would you view a law limiting your maximum hours? That is such a good answer. You have no idea. What's big bread? I love that answer. It's like the thing I heard all day. What's big bread?
That could hire like multiple shifts of workers.
Oh. What's that? You want to add something?
No, you said it.
No, there's no irony there. So let me just lay this out for you. At the time, where would you get bread from? You can go to a store where big bread, to use Ryan's thing, like, you know, these large facilities. And what they would do is they'd have, you know, shifts around the clock, right? By the way, everyone's made bread, right? The most time-consuming part of baking bread is what? Letting the dough rise. So in other words, you make the dough, you knead it, you let it rise for a few hours, and you have to bake it. So a lot of just sitting around time doing nothing. So what often would happen is you have these shifts, right? Where one group would make the dough, you let sit, someone else would then put it in the oven, and you would, you know, make the process. Big bread, big bakeries were able to absorb this cost because they're able to have many workers. They have 2 or 3 shifts a day, 24 hours around the clock. But if you were a small immigrant baker and you only had a couple people, what we do, you'd make the bread, you'd go take a nap, right? And then you'd wake up when the dough's ready to rise and you'd cook it. These laws were largely designed to punish small immigrant bakers. Be very, very clear about that. Right? People don't like when I say this. I'm sure Professor Lasser didn't mention this. These were not helping workers. You might think, oh yeah, who wants to work so hard? That's a very nice thing to say. But when you need to put food on the table, you want those hours, right? You want those wages, right? So the people who loved this law were the larger bakers, big bread, to use Ryan's colorful metaphor. And it was actually the small Joseph Lochner was an immigrant, right? He was making bread with one of two of his colleagues in basically these like so Lochner actually has his own bake shop. He had a storefront. Actually, I am so proud of this. I found this picture. Randy did not give me credit until I joined his casebook. Right? I actually, where is it? Yeah, there it is. I found this picture in a it's not called a phone book, so there were no telephones. It was like basically the equivalent of a phone book before phones were existent. But he had a beautiful storefront. He has Lochner's Home Bakery. You can see that right there. So he had a beautiful bake shop. But a lot of these bakeries were just basically in basements inside New York. So let me give you sort of a concept. Anyone ever hear of the concept of Baptists and bootleggers?
No.
Anyone hear about this? So it's a very important economic concept. I'll give you an example. Who loves prohibition? Who really likes to ban alcohol? Two groups, the Baptists and the bootleggers. You're smiling, you see what I'm saying, right? Why? So the Baptists are moral, they are just, and they think that the road to salvation is by banning vice, including liquor. Good for them, right? That's their belief. But then who also loves prohibition? The bootleggers. Why? They can jack up the rates, they can make their moonshine and sell it off the books in a speakeasy for a lot of money. So you'll often have regulations with both perhaps a good motivation and a not so good motivation, but they come together, right? The Baptists and bootleggers say, yes, let's ban alcohol. If you don't believe me, I think I asked, does anyone live in a dry county? Is there a liquor store right by the border? Yes, ma'am. You better, and you know why your county's still dry? Because that liquor store. They're lobbying to keep that county dry, to keep their monopoly. So health regulations are much the same, right? So who favors maximum hour loss? You have the progressives, like Brett's like, we need people to have more time to relax. Sorry, I'm not making fun of you, you were next, right? People who can time to relax, have time off, not work so hard, right? If they're really tired, they make bad bread and so on. Those are the Baptists. Think of the children, right? Then you got the bootleggers. It's like, screw this, we're gonna kill our competition, right? Big bread. Put these bakers out of business. So in any sort of regulation, it's actually called the Baptist and bootlegger metaphor. People come together and they make these coalitions that are not obvious. And that's how I sort of view this law. What's interesting with the Bake Shop Act is that there were many provisions. So one, for example, regulated draining and plumbing. That was valid. The court said that law was fine. No one regulated how high the ceilings had to be. You know, if you have enough ceiling space, there's more ventilation. Okay. Another one said that you can't keep animals inside the bakery. The court upheld that. Who's going to fight that one, right? Another one said you have to have washrooms. You can't sleep in the bake rooms. The court upheld that too. One required inspections. The court upheld that. Almost the entirety of the Bake Shop Act was upheld, with the exception of the hour law, that you can't work more than 10 hours in a day or 60 hours in a week. By the way, you could work in 2 different bakeries for 80 hours a week. Oh yeah, you just couldn't work in one bakery for more than 60. So you see why big bread, this is big bread right here, like this law. It didn't actually save workers. It just limited competition. And you can be sure if the bakery says, sorry, you work 10 hours a day, you go down the block to another bakery for another shift. Yeah, I realize it's sort of unfair, and I'm not one to speak, but law students, oh man, I work so hard. I was, studying all night in the air-conditioned library in my nice building. Working conditions are not always so pleasant. I'll just leave it there. So I'm saying, true on that. Who am I to speak? What do I know? I sit in an office all day. Okay, so then we get to the Lochner decision itself. And the court here splits 5-4. There's a majority opinion by Justice Rufus Peckham. That's him, Peckham, a little mustache. And then you have 2 dissents. One dissent was by Justice Harlan. We've talked a lot about Justice Harlan. He was joined by Justice White and Justice Day. Then we have another dissent by Justice Holmes, who we may have mentioned once or twice, but Holmes and Harlan were giants. And actually, Harlan was like 6'6". He actually was very tall, so he was a giant. Holmes wasn't very tall. But Holmes was a remarkable human being. He served in the Civil War I think he was shot twice and survived both times. That doesn't happen. Usually you get shot once, you go home in a box, right? You go home in a box. But he survived. He was a very remarkable person. And Holmes's sort of judicial philosophy was one of we might call restraint. That we, the judges, should not be in the business of second guessing whether a law is reasonable or not. Harlan would say if the law passes the legislature, that's probably good enough for me. Harlan, though, doesn't quite take that view, and we know that. How do we know that? He dissented in Plessy, didn't he? And in Plessy, what did he say? This is not a reasonable law. This is a law that's made to treat people unequally. So Harlan can't go with Holmes on this one. Harlan says, well, we have to look at the evidence and see, does the evidence justify their law? And Harlan ultimately says the evidence does not justify this law. And you have the majority by Justice Peckham. I'm sorry, I said misspoke. Harlan said the evidence does justify the law. I misspoke, I apologize. Harlan said the evidence is enough for this law, but he looks at the evidence. And then you have the majority opinion by Justice Peckham, and Peckham's like, nah, this doesn't cut it. This does not cut it. So you have these three sorts of schools of thought. When I asked at the beginning, who determines if a law is arbitrary? These are three sets of judges who have very different opinions whether the law is reasonable or not. And I mean, again, I go back and forth, but I think I usually wind up with Harlan. That's usually where I wind up in this case. But I sometimes feel a little peckish, maybe. I feel a little Peckham. But usually I wind up with Harlan whenever I teach this one. Never Holmes. Holmes after Marshall is the most overrated justice. So if you want one, who the most overrated justices, in that order, Marshall, then Holmes. I will take that one to the bank. It's true. Yes, sir. You're smiling. I'm in trouble.
So in terms of Holmes' judicial restraint, it's difficult to not side on him as the result of without judicial restraint, judges who create substantive due process.
Oh, you're right about that, sir.
So, like, yeah, I want judicial restraint, although sometimes I think the law needs to be.
Well, we'll do a case. I think we'll do a case on Sunday. I can't remember the calendar. Yeah. So we'll do a case on Sunday called Buck v. Bell. Did anyone read that one yet? I'll come to you in a second then. This is a case about forcible sterilization of women who are deemed imbeciles, where the court deemed Carrie Buck an imbecile, and they sterilized her. And Justice Holmes basically said, if the government decides it's a good idea, yeah, that's fine. So that's restraint. Yeah, that's restraint right there. So you like it? You like it with the bakery? All right, let's see how it goes when it comes to sterilization. You were not expecting the answer, were you? No, I threw it right back in your face. I'm sorry. Trent, was your hand up? Yeah. I want to come to this. I want to come to that point in a minute, I promise. Stephen? Interesting. And what about the other 70%?
Which I like more right now. So
Well, I'm going to ask that question in a few minutes. Just, you don't need to think of an answer now, but I'll ask you guys in a few minutes after we cover the case. Which opinion do you find most persuasive? The majority by Peckham, the Holmes, or the Harlan, or the Holmes? Just, I don't need an answer now, but just start thinking about it. All right. Alexandra, I think you're next. Or did I not? No, I didn't actually call on you. You got a freebie. Yeah, come back to you. All right. Walk me through the majority opinion, please. What's the majority's analysis? Oh, that's interesting. So they said, is this really a dangerous profession? Right. So I mean, I'm only giving you a couple of these cases, but there are other cases involving mine workers. You want to see a dangerous profession? Working in a mine where the thing can just collapse on you any moment. There could be a gas leak, right? You become suffocated. And the court actually upheld restrictions on hours in a mine. They said, look, if you're working an 18-hour shift in a mine, you know, maybe you may not be the best safety person, right? Maybe you might fall down, maybe you might trip and die. But what the majority says, and I think you're correct, is that this is not a particularly dangerous profession. Now, I actually had a student working in a bakery a couple of years who said, no way. He says it's hot, it's sticky, there's a lot of dust in the air, a lot of flour in the air. It's actually very hard to get around. And who am I? I've never done that. So what do I know? Can't bake anything. But the more basic issue, Alexandra, let me come to you, please. What is the right of contract? They kind of speak about this, the right to make contracts. What is this right? Whose right is this, Alexandra? Okay, good. So you often see in the cases this concept of what's often called right of contract or liberty of contract. You'll see it sort of both ways. And this is the right of the worker to make a contract on the terms of his choice with an employer. And the government can't interfere with that right. Now, just taking a step back, almost every aspect of your relationship with your future employer is regulated. What wages they can pay you, how many hours you can work, what are the conditions where you can work, and so on, right? There's so many laws, federal and state, that govern the relationship between a worker and his boss. There's like thousands of these laws that exist today. But back in the 1900s, that didn't exist. If you wanted to work, you would make a term with your boss and either take it or leave it. Maybe it was an adhesion contract, perhaps, but you make a contract and you stick to it. And if the boss doesn't like it, they can breach it and fire you. And if you didn't like it as a worker, you can just quit and walk off. The concept of a union was not really, they had unions, but unions had only one remedy, which was to strike, right? Hope they could have enough force on the employer, right? There was no requirement for the union to work with the employer. The union could just say, all right, we're going to fire everyone in the union. So this was a sort of this novel model that the state would sort of get between them, and it was done to protect them. We'll do later this class the Adkins decision, and that's a hard one for people to get because on the one hand, it's like, wait a minute, these women are going to starve. They need money. They need these wages, right? But on the other hand, it's wait a minute, are you saying that men can negotiate their own wages but women can't? Are they inferior? So in one sense, it's about equality. In the other sense, it's about not equality. It's actually a very, students often struggle with that. Okay, we'll move on. The court asks, is this a legitimate exercise of the police power? Okay. How do you know whether it's legitimate exercise of the police power? It's not enough to just say it's for protecting health and safety. All right, that's not enough. Why? Because there might be a pretext. The government can't just come and say, oh yeah, this is for health and safety, right? I asked this question, 30 minutes ago. You have to do more. You have to show that there's an actual valid reason for this act. That the power cannot be exercised arbitrarily. But how do you know if the law is valid? How do you know? The court says there is no reasonable ground to interfere with the liberty of person of contract by determining the number of hours. No reasonable ground. This is what Anna tries to do. I said you can't do it. These were reasonable. The court does it. Why? The court says bakers are intelligent. They have capacity. They can assert their own rights. They are not wards of the state. People do not need it. And by the way, again, this was a case where a worker wanted to work more than 10 hours a day. No one was forcing him to. He needed that money. Right? This was his livelihood. The court says this law is not about safety. It's not about morals, not about welfare. It doesn't protect health. Clean bread does not determine how many hours you work. That's probably not true. It's probably the case that if you work more, maybe you become sloppy, maybe you drop the bread. But there might be rationales, but the court's saying that's not what this law is about. And then we get to the idea of a means ends fit. Stephen, I promise you I'll come back to this. I remember usually. Usually I remember, I don't always. Okay. Means ends fit. This is a concept that students, I think, struggle with. I'm going to try to explain it now, but I don't think it's not going to click. It'll click maybe a few later. Where is it? I have it here. I don't know. Here it is. Yeah. So this is for the Adkins case, but I can use it here. So whenever you think of a law, and you try and determine if the law is rational or not, we think of these two sort of categories: the means and the ends. If we have the expression "the ends justify the means," congratulations, you've done constitutional law, right? That's what that expression is about. What is the law trying to accomplish? Those are the ends. How does the law accomplish those goals? Those are the means. In other words, what are you trying to do? And what are you actually doing? So let's say the end here, the goal is to have healthy bread. Okay. How do you get there? Sanitation inspections. Okay, that's good, right? Regulating the height of ceilings. Okay, that's good. Make sure cats can't live in the bakery. Okay, that's good, right? There's a good fit between banning cats and having clean bread. Everyone agree with me on that one? What about the fit between 60 hours a week and clean bread? The relationship there isn't quite as good. It's not close. It's not a close fit. Because again, you could work 60 hours in this one bakery and they work 60 hours down the street in another bakery. And you're the same person doing the same sloppy work. So what the court would say here is that the fit, the relationship between the means and the ends doesn't really work, right? There's not a really good relationship between the means and the ends. The relationship is not direct. Think of the direct effect test. Like, is the regulation of local wages really about interstate commerce, or is it about trying to regulate the wages? And when the court says that there's not a good fit between the means and the ends, it tells you something. It tells you the reason they're giving you is not the real reason. They're not really regulating the wages and the hours to have healthier bread. They're doing it to control business and perhaps limit competition. In other words, you can't simply say health and safety. You need to do more than that. You must show a fit between the means and the ends. And the Lochner court says this cannot be done. Michael.
Is it accurate to say that like this is like kind of what we've just been doing the entire class?
Isn't that something? Yeah.
I thought it.
Yeah. You've been paying attention. It's good. There's nothing new here, right? This class is kind of like building a cake, perhaps no pun intended. There are a lot of layers, and you don't even know what the cake looks like to get to the end. That's why this is a hard class to teach. I'm like teaching stuff without actually telling you what it is. And later it's like, oh, you remember this case like 4 months ago, 4 weeks ago? I come back to it. This is a very hard class to actually see the forest when you're stuck in the trees. And eventually, like halfway through, it's like, oh, that's what we're doing. Now I get this class. It clicks. Yes, sir.
Like, we're doing like necessary and proper, right? The reason why we're doing that test is because it's like unenumerated, so it's like whether it's appropriate. Because that, I get why that needs to be like a close relationship.
Yeah.
There's no like language, I feel like, in the like police power rule that says like you can go further than, like use unenumerated.
Well, I mean, what's due process of law and what's liberty? And that's language. I don't know what those mean. They mean something, right? But yeah, there's similarities between the necessary and proper clause, whether the law is proper and whether it's a reasonable exercise of the police power. It's the same inquiry, right? It's not dissimilar. Judges, I'll say it like this, are not very creative. That when there's a new test, new clause in the Constitution, they apply what they already know, right? Judges apply what they know. I mean, you'll learn about this, modern search and seizure law is based on trespass law, right? Why is that even a thing, right? It's what judges know.
Weren't they doing like a deferential standard in the necessary and proper clause where it's like the means can be really distant.
Yes. Yeah, that's what, I mean, that's what Marshall said in McCulloch v. Maryland, right? That's not for the courts to second guess the legislature. If they determine this is a necessary and proper law, that's probably good enough for us. It wasn't really to the Obamacare case, the court said the law was not proper. Or maybe Prince, but how you define it. Okay. So one last point, I'll go back to our graphic. There's a concept that's called tailoring. Tailoring. What does tailoring mean? And I think I use an analogy of like a suit, right? Let's say that you go to a very fine suit shop and they measure you precisely and they fit a suit that fits you perfectly. There's no wrinkles, no creases, everything just looks great. Okay, that is a suit that's very finely or narrowly tailored, right? The fit between your body and the suit is perfect. Okay, let's say you go to Sears. Does Sears even exist anymore? No. Kmart doesn't exist. Sears doesn't exist. Okay, you go to a cheap shop, right? You go to, just a cheap shop and you buy whatever suits off the rack. It just kind of hangs on you. Is it narrowly tailored? No. Is it fit great? No. Okay, but look, if you're just wanting to look in a suit, you don't really care what it looks like. When you're dealing with constitutional law, we have to ask ourselves, how good does a fit have to be? Are you okay with just like a shabby suit that hangs off your shoulders? Or you want a very fit, narrowly tailored suit? What the court in Lochner is saying is you need to have a very close fit, a very narrow tailoring, a very direct relationship between the means and the ends. Think of the direct effects test, right? There has to be a close fit between your local regulation of commerce and interstate commerce. Is there a close fit? It's the same judge deciding these cases at the same time, right? You learn them sort of separate, but they were really decided in the same years. At the same time, they're deciding law. They're saying it's a direct effect on commerce. It's the same judges. How close is a fit? They want a tight fit. By contrast, Harlan says, no, the fit doesn't have to be great. If it's in the ballpark, that's enough. Right? And then Justice Holmes says, you don't need a fit. You can be naked. I don't care. Right? Doesn't matter what you're wearing. You can wear a burlap sack, and that's good enough for Justice Holmes. He'll hop around and do a potato sack race with you, right? He doesn't care. All right, any questions so far on the majority in Lochner? One last point on the majority in Lochner. The court sort of gets at the big bread part that Ryan mentioned a few minutes ago. They said the real object of this law was just to regulate hours. This is not about helping people, it's punishing businesses. Okay, questions the majority. Yes, sir.
So this I mean, so I guess like means to ends in the context of trying to see if something is like the within the state's exercise. I guess damn, this is so hard to
It's okay, take your time. I think I know what you're asking, but go for it.
So I guess it's important to whenever you're thinking about the ends, you have to kind of see if what the end is
Oh.
yeah.
Is the end itself legitimate?
Yeah, so you have to also kind of do
yeah,
another means ends with
I didn't get to this yet, but eventually the courts will say that not all ends are legitimate.
Yeah.
For example, I'll use Plessy as an example, right? What do? They separated people in the train cars by their race. And what was the end? To prevent people of different races from fighting in the train car. Just suspend your disbelief for a minute, right? If your goal is to prevent violence in the train cars, does it make sense to separate people based on their race? Kind of. At that time, yeah, for damn sure. But then Michael's point is it legitimate to actually have people separated by race to prevent violence? Is that itself a legitimate end? Well, that determines on what you think about race. And that's very much a judge-based inquiry. One second, Chelsea. In other words, to decide whether the end itself is legitimate. I mean, what did Marshall say? Let the end be legitimate, right? He presumed the end was legitimate. Having a bank was a legitimate end. But that is not always the way the court approached in the 20th century. Yes, ma'am.
So, I know you mentioned the other day that when they did try to force people to acclimate, there was violence. So
Yeah.
statistically or historically, it shows that. So would that not be a close fit where it is legitimate?
Why do you think they upheld the law in Plessy?
Right, because it's legitimate.
And the court, I mean, I didn't make a fuss in this one last class when we did Plessy, but if you read the opinion carefully, they're saying, look, there's a good fit between what the government's doing, what they say they're doing. There's actually a direct relationship there. There's a reason why the case was 8-1. What?
But I think there's some things that are just principles that you can't rely on.
Well,
a contingent
that's
argument to
Michael.
get to.
That's Michael's point. The green, that what the court does in the modern era, so you know what? Even if there's a fit between the means and the ends, those ends are not proper. That the ends themselves, like Marshall said in McCulloch, let the ends be legitimate. It says that very clearly, the ends, uses this language. Let the ends be legitimate. But judges today might say, nah, segregation, it doesn't work at all. That we'll do this in about 2 or 3 weeks. I don't remember exactly when. The court will say that there's no or almost no justification for racial segregation. That no matter how useful that might be, that the end is not proper. There's not a difference between this and necessary and proper. It's actually very similar. Constitutional law, who said that? We're doing this since week 1, right? Yeah, Michael said that. This is what we're doing. That it's coming to focus, right? Now you're actually seeing how everything kind of fits together. Your hand up? Go for it.
Shouldn't there be some type of like, is like, where in the Constitution do they give the Supreme Court the power to determine the end that Congress, who's elected by us, deems that they are evil? You know, like, even though it makes sense a lot of times, it's like, I just don't want these people to have them.
Well, isn't that what John Marshall said in McCulloch, that the fact that Congress passes this bill creates this bank in the United States, that's enough for me? That's kind of what Holmes is saying too, isn't it? That's why I put them in the same category. I think they're overrated. But Holmes and Marshall are like on the same page. They're reading from the same sheet of music. Well, we'll go think of one of the first major cases with Dred Scott, right? Where Tawney said that there's violation of due process. There's a reason why people hate Lochner. There's a reason why people put Lochner and Dred Scott in the same sentence. Because you're using this unenumerated, things that are not written down, power to take away laws enacted by the democracy. That the Congress passed the Missouri Compromise. Say, okay, no slavery above this line, right? That's what Congress said. And Justice Tawney said, no, you can't do that. It's unreasonable. And in the New York case, the bakery case, they said, okay, we're going to limit how many hours bakers can work. And the court says, no, that's unreasonable. People link Dred Scott and Lochner for that exact rationale. You know, what other case goes in that trilogy? Roe v. Wade. That one of the reasons why even people on the right hate Lochner so much was that's what led to Roe. Roe, abortion, substantive due process. They did that. The judges say, you know what? There's an important right to abortion. It's not written down, but you know, it's kind of in the ether. And we're going to take laws that people enact and say, oh, you can't do that. So maybe you like bakeries, maybe you don't like abortion. I don't know. I like bread, right? I like cookies, right? But it's the same doctrine. Now you could say, well, there's actually reference to property. There's also reference to liberty, right? What do these phrases mean? We can talk about them, but the basis of judges citing a law is not rational, it's not reasonable, is what happens in Dred Scott, Lochner, and Roe. That's why these cases are often linked in. This was Justice Scalia, I think, wrote either an article or a book where he analogized Roe v. Wade, Dred Scott, and Lochner. And there was actually a judicial nominee, I can't remember the person's name, who basically cited saying, how dare you compare Roe v. Wade to Dred Scott? Well, I mean, yeah, on paper, they're very different cases, but the legal basis are actually much the same. And when we get to the we get to the Casey decision, Justice Scalia actually compares. He basically describes Roger Taney's that photograph. Remember, Taney looks very sad late in life, and he basically says to his colleagues, "This is you, right? You are Taney." Oh man, he had a way with his words. Anna?
Maybe understand, but aren't these cases trying to also regulate morality?
legislatures and not,
What do you mean morality? How do you define that?
like, you said that police power sometimes includes morality.
I hesitate on that one, no, I always hesitate, yeah.
Yeah, sometimes includes morality. So if, you know, if this, the reasoning behind this is also to protect smaller bakeries from the hour wages, isn't that a morality question rather than a?
Do you remember the lottery ticket case? This was where they banned the sale of lottery tickets. And I think was it 1903? Check me the year. I think it was by a year or two. So it's right around the same time period. And what the court said there is that the states can prohibit lottery tickets, the Fed should also. So there's absolutely a sense of morality as well. But I don't think the majority, it's also a contradiction. The majority doesn't see morality here as well, but I think you could frame that way. Yeah, it's not wrong. Yeah, lottery ticket was 1903. The years are up there somewhere. Yes, sir, Bobby.
I think the 14th Amendment is what allowed them to start asking about what the state did, like prior to.
Yes, well, yes and no. So ironically, the part of the Constitution that's most important in the early 19th century was the contracts clause. The Constitution says that states cannot abrogate contracts, can't violate contracts. And almost all the big litigations are the contracts clause. So then after that, you have the 14th Amendment. That's a much cleaner basis to do it. But Slaughterhouse said, again, Slaughterhouse said that the PRI clause doesn't really mean right of contract. That's the butchers wanted. But what Lochner says is, okay, we don't do PRI, we'll do it under the due process clause. And who said laissez-faire before? Was that Trent? Oh, Trent. Oh, such a gentleman. Okay. You asked me the laissez-faire before, right? There's a very famous line in Justice Holmes's dissent. And he says, the 14th Amendment does not enact Mr. Herbert Spencer's social status. I think I have a picture of him somewhere. The 14th Amendment does not enact Mr. Herbert Spencer's social status. What a line. There he is, Herbert Spencer. Look at that beard. Look at that guy. So who the hell is Herbert Spencer? My goodness. Anyone ever hear of Herbert Spencer before? No reason you should have. So a lot of people say that he was a social Darwinist, which is not true. So who are the social Darwinists? They were saying, aha, Darwin, the theory of evolution, that only the strong survive. We should apply that to society, that we should let these weak, poor people die off and have a stronger civilization. Okay, those are social Darwinists. Spencer was more laissez-faire. He favored light regulation of government, that people can make their own contracts, and the law of equal opportunity, that people can choose their own path. And what Justice Holmes says is the 14th Amendment is not about this economic theory, about laissez-faire capitalism. And the majority basically says the contrary, that there is a concept of property rights, that there is a concept of labor, of right of contract in the 14th Amendment. Now, to Oscar's point, none of this is written down. It's not in the Constitution, but they understand it. Ironically, the same claim that the butchers raised, the right of contract, the right to pursue your occupation, was accepted in Lochner half a century later under the due process clause. So even though PRI was knocked out in Slaughterhouse, they rehabilitated it in Lochner. All right, I think I'm done with the majority. Alexandra, I think you've been waiting patiently. Oh, Taylor, I'm sorry. Thank you for your honesty. Taylor, walk me through the Harlan dissent, please. Again, Harlan had 3 votes and Holmes had 1. What did Justice Harlan say? Oh, let me stop you. You said something very good. The burden of proof. Is that what you just said? Taylor, tell me, please. What does that mean, burden of proof? What does that mean? How about justify? Good. All right, so let me tell you something. In constitutional law, right? In constitutional law, the most important question is who has the burden, right? In constitutional law, the most important question is who has the burden. When the government has the burden to justify their law, the government will probably lose. When the person challenging the law has the burden challenging it is going to lose, right? If you have the burden of proof, to use Taylor's language, if you have the burden of proof, you're probably going to lose. So in this case, the majority put the burden of proof on the government. The government had the burden to justify, why do you have this law? Why is this law valid? In other words, the government passed this law and had to defend its own law. Who had the dissent by Justice Harlan, Taylor? Who had the dissent? Where did the dissent place the burden? Correct. Yeah, the Bakers, right? Yes, ma'am. The Bakers had the burden in the dissent. The Bakers had to have evidence to show, see, this law is unreasonable. This is not about safety, it's about protectionism. So the biggest difference between the majority and the dissent is about the burden of proof. The majority who have placed the burden of proof on the government, New York, and the dissent, Harlan, put the burden of proof on the Bakers. Now, what about just Holmes, Treya? Who would he put the burden on? Can that burden of proof be overcome, Treya? Is there any evidence the Bakers could put forward to overcome that burden? Correct. Very good. So you see what Holmes did, right? Holmes said the Bakers have a burden they cannot meet. If any reasonable person could justify this New York bake shop law, it's valid. So imagine you go to court, right? And you just pass the bar, you're all excited, say, Your Honor, I'm gonna make an argument that this bakery law is unconstitutional. And the judge says, I'm not interested. I think anyone can find this law valid. I don't really care what you have to say, it doesn't matter. That's what Holmes is saying. It's like it doesn't matter what you tell me in your brief, because I can find some rational basis for this law. Someone find it reasonable, that's good enough. Harlan says, look, let's have a debate here, right? I'm going to look at your evidence. I'm going to see, is this enough evidence to stop the law? Holmes is like, I don't care about your evidence, whatever. It's good enough. They pass this bill, that's good enough for me. And the majority says, hey, government, you got to make a really strong case why you have this law, and you didn't make your case. There's so much work being done by the burden of proof, right? So this means and fit, right? Let me go back to this graphic from a few moments ago. The means and fit, under the majority, it's the government's job to prove an adequate fit, right? The government has to show there's an adequate fit. Harlan would say, no. It's the baker's job to show there's not an adequate fit. The bakers show that there's not a good fit. And Justice Holmes would say, I don't care, whatever fit means, ends, doesn't matter. Can someone find this law reasonable? All right, that's good enough. Holmes once wrote a letter, and I'm going to paraphrase. I actually get the quote. I don't want to botch the quote. He said, this is a true quote. He says, if my fellow citizens want to go to hell, I will help them. It's my job. If my fellow citizens want to go to hell, I will help them. It's my job. He believed that. He firmly believed if the people want to enact these dumb laws, then it's my job to help them do it. He himself probably didn't like this law very much. In fact, he said, if I had time to study it, I might come to a different opinion. He kind of was like, I'm not really sure, but you know what? I got a robe on. I don't have a legislature hat on. So screw this. Why are we wasting our time? You don't believe me? Wait till you get to the sterilization case for next class. You'll be like, oh, Blackman was right with that one. Holmes believed this in every fiber of his being. That's not his job to second guess it. Yes, sir. Presume. What do you mean? You're right. What do you mean presume?
That in any way the legislature attempted to justify restricting liberty, then they have the right to do it.
Presumption of liberty? Is that what you're asking about?
Yes.
Yeah. So there are these two presumptions that we've talked about before. A presumption of liberty, which what Randy Barnett calls it, my colleague, a presumption of liberty, and a presumption of constitutionality. A presumption of liberty, and a presumption of constitutionality. Justice Holmes favors the presumption of constitutionality, that we presume the law is valid unless there's some really good reason to tell us why it's not. Harlan and Holmes have a presumption of constitutionality, that we presume it's valid unless there's some reason to tell us why it's not. The majority now favors a presumption of liberty, that, we presume that the private citizen can have a contract with his boss, and the government can't do it unless they have a good reason for it. Who's got the burden? The majority presumes the law is invalid, and the government must defend it. And the dissent presumes the law is valid, and the bakers must knock it down. These burdens, these presumptions work together. Everyone see that. We'll talk a lot about presumption in this class. We say presume, it's a good word. Okay. Yeah, that's what I'm looking at. Yeah, he believed that if the democracy, if the democratic process, the legislature adopts a law, then who the heck are we to say otherwise? Who are we to say otherwise? To resolve breaches of contract, to resolve property disputes. No, I'm serious. He would say, judges resolve contracts, disputes, right? Property disputes. But constitutional law, that means the government wins. Again, I'll defend Holmes, at least qualified. He came from the bloody Civil War, right? He was shot twice. You don't live through two bullets without getting a perspective on life. And he's like, the way you resolve these conflicts is through political means. And if the people come together, as Trent said a minute ago, and they decide that we need to regulate bakeries, we need to regulate butchers, we need to regulate, laundromats, right? Then that's not for me to second guess. Who am I? Oscar said, where did judges get this power from? He's not wrong, right? He's not wrong. I don't think he's right either, but he's not wrong. These are, I think, contested issues about what judges are actually able to do. But just to sort of, I want to make this contrast clear between Harlan and Holmes. Harlan actually goes to the evidence. We said that before. He goes to the evidence, right? He goes to the evidence. He looks at mortality tables, right? What are the rates of sickness, right? Internationally, how many people are working in these fields? He actually looks at the evidence and he says, look, there's evidence here. And the plaintiffs can't knock down that evidence, right? In my view, there's enough evidence to support the law, the hours. Holmes is like, I don't care what the evidence says, right? I don't really care what the evidence says. He says, this is a side on economic theory that a large part of the country does not entertain. He says, you don't have the liberty to do as you wish, right? And he makes a couple points I want to talk about. There were laws about compulsory vaccinations. And to be clear, they actually weren't compulsory vaccinations. They would, it's a grievance of mine, but the government would fine you if you didn't get a vaccine for smallpox, right? He says, how can it be that the government can make you get a smallpox vaccination? They can't regulate your hours. He goes even further. The draft. People were drafted in the Civil War. Could it really be that the government can force you to go fight in a war, but they can't regulate your hours? He's not entirely wrong. And he says, what are we doing here? Why are we doing this? Right? The Constitution does not embody any particular theory, he says. The Constitution is made for people of different views. Then he says, this decision is based on judgment or intuition. Will. He's saying this is itself arbitrary. That the court is saying the law is arbitrary, but Holmes is saying, you know what? We judges are being arbitrary here. He says the word liberty is being perverted here. It's being perverted. At the end, he says, a reasonable man could think this is proper. That's enough for me. All right. Questions on Lochner, the three opinions. I'll ask my poll question in a moment. Which one, and there's no right answer, no wrong answer here. Which opinion Lochner you find to be the most persuasive? The majority opinion by Justice Rufus Peckham, the dissent by Justice Harlan, or the dissent by Justice Holmes? All right, get another 5 seconds. I'm just curious where we are. Wow. All right. I'm pretty sure any other law professor classes we skew the other way. But maybe that's my fault. I don't know. All right, so I see about 55% for Justice Peckham, about 30% for Justice Harlan, and about 20% for Justice Holm. That's fair. You want to opine or no, if you want, that's fine. Yes, Oscar.
I don't like the fact that the majority is saying, like, they're essentially deciding what a legitimate end is, but I do like the fact that they're saying that the government is invalid, so, no, just, that's actually.
All right, that's fine. That's fair. Anyone else? Yeah, sure.
Actually, true, like, they can just like pass out everything. They still kept like safety, they still kept the inspections, plumbing, they kept like doing stuff like protect people, but they just got rid of like the labor law. I thought that was like pro-capitalism.
Right. I mean, most people don't even realize this. They've held everything else in the Bake Shop Act. Most people forget that part. In fact, most people hate to say it's never actually read the entire opinion. It's actually a really short opinion. I mean, I give you an edited version in your book, but it will not take more than an hour to read from start to finish. It's not like, my God, the Supreme Court today, every opinion is like 100 pages. They had 2 opinions this morning, like 60 pages, 50 pages for like a stupid small case. I would, if I could, I would do lots of things. I would ban law clerks, make them write shorter opinions. I would make them work. Right, way too much. Oh, I got ideas. Keep me away from Congress. Yeah.
I think, in Harlan's, I think he's right in assuming that, like, it's not fair to assume that New York had, like, bad faith, maybe.
Oh, interesting.
Because, like, in the Abraham Lincoln with the sheep quote and everything, it's kind of fair to assume that by any passage of a law that one person is not gonna like it and another person thinks.
Yeah. Yes, I think Stephen said good faith earlier. Did you say that, Stephen, earlier in class? So I think when he said good faith, he's getting at your point that you raised, Anna, that Harlan presumes that the legislature of New York is acting in good faith. And the majority opinion is like, no, they're not. They're a bunch of corrupt legislators. So do you presume that the members of the elected government are acting in good faith, or are they just a bunch of just cronies acting? You said yes. Which one?
To the former.
That they're acting in good faith.
Yeah, I don't know. I think that's kind of silly. I mean, because like the people do kind of like literally get elected by people. So like I don't know, just to presume that like everybody's like I don't know, that all the people in the legislature are just doing stuff,
Bad stuff. Yeah.
Yeah, like just doing stuff that's
Yeah, I think that's right. I think generally people go into government to help their constituents, help people. And even if they're acting, let's say, a fashion that I might deem to be inappropriate, their voters apparently like it because they put them back in office, right? If a legislature votes for a lot of bad laws, they get voted out of office, don't they? I think, maybe not. I don't know. Yeah, no.
That I like the majority because I felt like it was about monopoly and
Well then, I'll speak of monopolies. What about slaughterhouse? Is this law any worse? Is this law better or worse than the butcher monopoly in the slaughterhouse cases? Which law is more restrictive of the businesses?
How would it say that?
Yeah, here you can at least have your own bake shop.
Yeah.
There you have to go to the government's run facility to kill your animals. Sheldon.
I come down, I think, on Harlan's, but I am very pro, right to contract. But I think it would be silly to believe that, the right to contract is unlimited. There are some times in which, like, a truck driver should be able to drive 24 hours a day. But then, also, because my job and my money, I don't need to believe it, so, like, I'm not.
Well, you're the wolf. Are you the wolf or you're the sheep, right? This is Anna's question. Which are you, the wolf or the sheep? Yeah, you're the wolf.
Yeah.
Yeah.
I'm okay, like, if I'm the wolf, then I'll kill the shepherd, but.
Yeah, kill the
like,
shepherd.
I don't know how to reconcile it, because it is necessary in some instances.
Yeah. But what we're talking about, again, there's no clear, the 14th Amendment doesn't say government cannot violate the right of contract. That ain't there, right? That's not there. You have to basically infer it when you have liberty and due process of law. Now, I think there's actually, maybe I'm an outlier, but I think there is a basis for right of contract in the Constitution. But it's not clearly there, to be candid with you all. All right, anything else on Lochner? If we go to Muller, we're gonna do a little bit of whiplash in a minute. Nothing else on Lochner? All right, good discussion. All right, let's do question 5. Let's put this one on the board. This is a short answer for everyone, please. Question number 5. Why did Oregon restrict the number of hours women could women could work? And this goes to the good faith question also. Let's say you're real good faith. Yeah, the bakers, rah rah. I don't know about this one now. You're smiling. You're smiling and nodding at the same time, and that's a good combination. And I think Julianne, I think you're next, so you'll be on deck. Oh boy, yeah, this is a hard one. Oh, maybe not hard, but it's really good discussion, I think. Okay, we just going. All right. I'm still here. All right, Juliana, help us out here, please. What did you put? Yeah. Let's be more precise. Why? Okay, so again, were there any limits on the number of hours that men could work in the laundromat? But there were limits on how many hours women could work in the laundromat. Would you say this is a pro-woman law or an anti-woman law? Okay, tell me why. Well, isn't it be pro and it's helping them, like parents said, they're not working so hard, give some time to relax? Angelica, you wanna raise your hand?
I would
Yeah.
say that was next. But I said, like, if they wanted to work so hard.
So if the woman chose to only work, 10 hours a day or whatever it was, right? She could choose that, but she wants to work 15 hours a day, she'd be allowed to do that also. Right. So I think the two of you sort of got what I was looking at, right? So the Oregon law, as we know, limited you to 10 hours a day for a woman. There was no comparable law for men. So you might say, on the one hand, well, this is protecting women, right? Women have to work too hard. And you might say, well, Angelica says, so they want to work more than 10 hours, let them work how many hours they want to work. Whose business is that? The government. The basis of this law, and that's sort of the answer to my word cloud's gone. The answer to this question was viewed as the sexes were not equal physically, not just talking about like legal equality, but that they couldn't work that much. But I want to sort of go a little bit deeper. Carleen, I think you're next. So do you remember in Bradwell v. Illinois, this was the case with Meyer Bradwell wanted to be a lawyer. Justice Bradley wrote this very sort of notorious concurrence, and where he said that women should not be allowed to be lawyers. What was sort of the gist of his dissent, concurrence? Why was he taking that position? Okay, you're right on track. So what was the concern of the state if women working too many hours outside the home? And wouldn't be able to contribute what? Children. That's what's going on here. The idea of women working in a factory or in a laundromat or something like that was kind of a novel idea, right? I'm not exaggerating much. You know this. Women were considered to be in the home, right? Having careers was not something that was happening. And the fear was, well, if women work too many hours, they might not be home enough to have children and rear their children and raise them. But it was actually even more than that. So the Oregon law was offended by Louis Brandeis. I have a picture from somewhere over here. Where is he? Yeah. So Louis Brandeis was probably one of the most famous lawyers of his day. And he created an entire approach to litigating where he would put a brief to the court, to Louis Brandeis' counsel. That I used to look at that, by the way, before COVID ruined me, I guess. It was not long ago either. It was like 7 years ago. Brandeis would put these briefs to the court, and he didn't make legal arguments. Instead, he would make these factual assertions. And these briefs became known as Brandeis briefs. They were named after him because he was a brilliant lawyer, whatever you want to say, but he was brilliant. And he would try to say, look, okay, Lochner says you have to have evidence. Here's our evidence, right? Lochner says you have to have evidence why the bakery is unsafe. Here's our evidence. And he would make these legal arguments about why these progressive laws were justified. And this one in particular, you can Google it. It will not be hard to find, the Brandeis brief. He made some pretty aggressive arguments where he tried to see the evil effects of working on childbirth and female health functions. And the state needs to protect women, morality. We want to talk about morality, kids, right? The effect of women's overwork on future generations. The physical differences, and I swear to you, these are actually in the brief. I got some quotes here. And this is all, by the way, junk science. It's not real. Or it's not real, we know today. He says that there's more water in the blood of women. I don't know what that even means, but that's in there somewhere. That they're inferior. If you actually read, he basically implies, and I swear to you, this is true, that if women work too hard, their uteruses will fall out. They actually were worried, and this is actually a reason why they should be athletes as well, that if they work too hard, their reproductive organs will basically stop working. I mean, almost everything he says there is like not accurate. It's just stuff they kind of just made up. But this was viewed as like, okay, we read Lochner. And Lochner says you have to provide enough evidence to justify fit between the means and the ends, right? So if our ends is making sure women are still reproductive members of society, we need to limit their hours. What's the fit between that means and the ends? You have to show that, in fact, if they work too many hours, they will lose their reproductive organs. You're all just laughing at me, but I'm telling you, it's right there. It's in black and white. It's the opinion. And that's what the court says. Lochner was a sharply divided 5-4 decision. We get to Muller. What's the vote? Unanimous. Right, 9-0. Similar, Slaughterhouse was 5-4, wasn't it? And when you get to Bradwell the very next day, only had 8-1, just as Chase was in dissent. So the sort of, your student says, Josh, right. So it's pretty clear, at least from my podium, that the court was concerned about the rights of contract of the men. But they seem to be a little bit less concerned about the rights of contract for the females. But then we get to Adkins in a few minutes. That just flips it all around, right? Adkins is like the sort of the bookend of Muller. There's not much I actually want to talk about Muller. There's really not much there. I want to talk about anything about Muller. I think I got the highlights. It's not very, like a couple pages. Yeah, it was 2 pages in your book, 3 pages. It's not very much, but I think I got the gist across. Anything else on Muller? I'm sorry? You think it's valid? Tell me. That is true.
I mean, the means to the end, like if this was all what they included.
Yeah. Yeah.
Then that fits, because then our world is gonna become extinct in theory.
Okay, so we're gonna do a case in. Actually, is it Sunday? I have no sense of time. I don't know what to tell. Yeah, we'll do a case on Sunday called Meyer against Nebraska and Pierce v. Society of Sisters. These cases are about the rights of families. And what the court says in Meyer and Pierce, and it's actually exactly what you just said, Chelsea, very, very good point you made, is that the most important thing we can do as a species is reproduce. They said pretty clearly that they refer to marriage as a noble relationship. And why is it noble? It's the only means by which we propagate our species. That if we stop having children, we cease to exist. And what's kind of weird is at the time, the trend with the fear was we have too many children, right? That we'd actually have starvation. There would not be enough food in the world to serve. So you actually have these things, the Malthusians, like Malthus, right? Malthusians believe too many people. We need to have fewer population, right? We're gonna have starvation and famine. And the 20th century actually sort of flipped it because they said, well, we can find new ways of making food. So now the problem is actually like the opposite, where populations are declining. You may not be paying attention to this, but look at China. They have this one child policy for all these decades. They're underpopulating. They don't have enough kids to support their old people. They're living too long. Italy, Japan, other countries, the hierarchy is inverting. So I don't want to get too into the weeds, but if you actually read Roe v. Wade, we'll read it in 2 or 3 weeks. The court actually hints that a justification for abortion is overpopulation. It's in there. It's right there. So your point, Chelsea, is well taken. That if you actually need to have society to reproduce, then yeah. Now, what do you do with a case where the science is so clearly bunk and junk, right? How do you do it 115 years later with society, the science is just all wrong? There are lots of cases we'll read this semester where the science we're relying is wrong, which raises the question, should judges be basing a ruling on social science data? Is the Brandeis brief legitimate? Should courts say, I'm not an economist, right? I'm not a labor, expert. I don't know. I don't know what blood, water, I don't know this stuff. Yes, judges do it. Judges on IP case, Malia's not here. I mean, you want to see the Supreme Court mess something up? Let's do a science case. Like they analogize. Oh, it's like this, it's like this. They don't know what the hell they're doing. The IP cases are very hard for the court because they're out of their depth. I was going to get there, but yeah. So one of the issues in the segregation cases involving Brown versus Board is about social science. There's entire footnotes, footnote 5 or 7, I can't remember, with all these studies about race and education. All of them were basically, none of them hold up today.
I should have just said, no,
Not a contingent question.
it shouldn't have made a contingent argument based on science.
It's risky when you have these Brandeis briefs, right? Because you are invariably relying on stuff that may not be true. I think judges stay in their lane and do law, but what do I know? What do I know? I don't know anything. Let's do Buchanan. Buchanan v. Warley. Now, this is an interesting case that doesn't fit into most case books. Most common law books will not have this case, which I think is a mistake. I actually added it. Randy did not have it, and that's one of the first things I said. You got to add Buchanan. He listened to me. We work back and forth. Oh, we're almost at the 5th edition. It's gonna be completely different. It's gonna be so different. You're not gonna have to deal with it, but we're very different. Have you ever heard of Buchanan before? Okay, so do you do Shelley v. Kramer and property? Okay, so Shelley v. Kramer was from 1948, maybe plus or minus a few years. Shelley v. Kramer involved restrictive covenants, right? So what's a restrictive covenant? A restrictive covenant is a private agreement where a person owns land and they put a restriction saying this land going forward can only be sold to people of a certain race, right? The court in Shelley in the 1948 or 49, Justice Stevens clerked that year, so it was 47. God, I'm blanking. Shelley v. Kramer, 48. Okay, I was right. Shelley involved a private agreement, and the court held that those private agreements were unlawful under the 14th Amendment. Dubious holding, but that was a holding. But the reason why we got to Shelley was because of Buchanan v. Warley. Long before we had private agreements, cities tried to segregate their communities. That's what happened in Louisville, Kentucky. Actually used to live there. Okay. Louisville, why am I talking so much? Oscar, what are the facts here? And giving it away. Oscar, what are the facts in Buchanan, please?
So essentially, I think it was Buchanan who was trying to get specific performance on Warley for a sale of land. And the thing about it was that he was white and he was black, right?
Okay, interesting. So who was the plaintiff here, the white guy or the black guy?
The white guy.
So it was a white person trying to buy a home in a black neighborhood.
Yeah.
It's the opposite of what you might think. This was a test case, right? The NAACP and some of the groups said we wanted a case where the plaintiff is white. Because you would think, well, black or something. No, it's actually what did the Louisville law say on Oscar?
There was an ordinance that prohibited it.
Right, or actually buying the property. You could actually live interracial, and this is actually somewhere that you rub. They anticipated that white people have black servants. So it wasn't that you couldn't live there, you were actually carve out having servants the opposite rate, because you couldn't have title to property. Yeah, they thought of that, don't worry. So what's interesting here is this goes to the court. Now, Elizabeth, what's the most relevant precedent that we've studied so far about whether you can ban and sell property people get off? What's the most relevant precedent? Big ones, good last class. Relevant precedent. More reason, more reason. The vision of the exam was impressive, it's right here, if you're 1972, impressively relevant. Why is plenty, try it again, why is plenty relevant here? Blacks can sell to whites, whites can sell to blacks. This is straight up Plessy, isn't it? So again, when you see the legal decision, you see how the government forms the laws through the legal decisions. If the law only said a black person can buy a white person's house, that would not be fair for equal, though, it's separate. So Louisville wrote a law that literally fit within the bounds of Plessy. So they couldn't challenge it on equal protection grounds. This was not an equal protection case. Instead, Shelton, what provision they rely on in this case? Due process. So tell me, what's a due process analysis here?
But it has to be, whether or not, due process of, that liberty was restricted, that due process, liberty, right? To, acquire, sell land.
Correct. This wasn't contract in the sense of a, employment relationship. Instead, it had to do with acquiring property. So there are lots of laws regulating the acquisition of property. But here they said the law was basically unreasonable, unreasonable violation of property rights. Am I done? Conrad, I think I'm back to you, my friend. Why was this law unreasonable? Why did the court declare this law unlawful?
It's because the purpose of 14th Amendment was to protect the right to contract and the right to buy land. So this is against the intention of the Constitution.
Did they talk about race much here?
It was really more about like all men's right to contract.
Wasn't that not what you expect, isn't it? And just Conrad, just finish the thread. Why were they talking about race here? What was the controlling precedent?
It would be, I guess, Plessy.
Yeah, that's Anna's point a minute ago. They can't talk about the obvious reason why this law exists. But the obvious reason this law exists is to create racial inferiority, to ghettoize, right? To have some people live in this neighborhood and other people live in that neighborhood. And you basically keep people where they're living. You prevent mobility. That's what this law exists for. But they can't talk about that because it's literally separate but equal. So instead, you have a case where the due process clause, that the liberty provision, actually guarantees the right of contract, the right of property acquisition. And so the court declares this as a violation of substantive due process. Again, it doesn't fit the narrative. This is 40 years before Brown also. But this is a case where the liberty clause, due process of law, was used to protect minority rights. Most people don't have this one in their casebook. I think it's an important case, but don't pretend this happened a lot. This was kind of an outlier decision. All right, everyone with me on the case. Justice Holmes did not dissent here. He tried, but he couldn't. This is in the reading. He actually wrote a draft dissent, which we have in our book, we discuss. Most people also don't know this ever happened. I do because I went to George Mason for law school. Holmes basically said, this is a manufactured case. We shouldn't be doing this. And basically, the plaintiff here is white. The 14th Amendment was not meant to help white people, to help black people. Why are we wasting our time here? But Holmes couldn't get a second vote, so he just dropped it. So Good old Ollie. Steven?
It's like, the holding in this one was just that, like, they violated substantive due process because you weren't able to, like, dispose of and do what you want with your property.
Your right to property, yes, and reasonable regulation. In other words, think of the means and the ends fit, right? What is the government's end here? What are they trying to accomplish? Yeah, I mean, basically, the end is segregation. The court is basically saying that that's not a legitimate end. Look, if your goal is segregation, that's your goal. And the means you're trying to accomplish this is by saying, okay, you can't sell to someone of the opposite race. This is a very good fit, right? The fit between the means, the end there is tight. But the court's saying is that's not a legitimate end under the 14th Amendment. So this was the court basically saying we're not going to allow segregation. Trent, will you handle? Good luck. I think he'll probably have dismissed the case and we're not going to decide at all. What he'll just probably said is, we shouldn't be in the business of ruling on statutes where it's a manufacturer test case. He wouldn't have done that one, I'm guessing. But yeah, I think he probably thought this law was he probably thought this law was valid, but he was just kind of just complaining that the case came this way. I don't think he would have said the law is unconstitutional. All right, what else? All right, but this is one of the rare cases where the court declared a law invalid under the 14th Amendment. It doesn't happen very often involving race. Alrighty, we're running to the end. The last case, Adkins versus Children's Hospital. Very important decision, 1923. Bobby, I think you're next. Want to give me the facts, please?
Yeah, so a woman tried to work at the hospital, and I believe they were.
Where was the hospital?
It was in DC.
Why is that relevant that it was in DC?
Because the 14th Amendment didn't apply to the 5th.
Correct. So just to be clear, almost every case we've read so far has been about the due process clause of the 14th Amendment. Here we're talking about the due process clause of the 5th Amendment, which is exactly the same, but it's the 5th Amendment that limits federal power. All right, go ahead, Bobby.
But yeah, it's DC, so obviously the 14th Amendment didn't apply because it's not a state.
Mhm.
I guess it's a federal territory. And then they also kind of have the presumption of validity in favor of Congress, maintaining that. They also say that like you do kind of have the right to control who you contract with in your labor.
Yeah. So Brian, let me come to you for a minute. Is this case consistent with Muller? Isn't the premise of Muller that women are inferior and the government should be able to protect their health? And here they're saying the opposite, it seems. How do you reckon? Okay, maybe you can. How do you line this case up with Muller? What does Justice Sutherland say? He tries.
He said that it gives them the equal right to obtain from each other the best terms.
Correct. Right, but why in Muller does it come out one way and in Adkins comes the other way? What happened between Muller in 1908 and Adkins in 1923? Something big happened, really big happened. What was the 19th Amendment? Suffrage. So Justice Sutherland, again, was a suffragist. He wholeheartedly favored granting the right to vote to women. Over here. Right? And he argues that lots happened over the last 20 years. Where is it? I keep going past it. A lot happened in the last 20 years. He says in 1908 at Muller. And Muller said that the destiny of women was to basically reproduce. But then in 1920, you had the ratification of the 19th Amendment. And that even if the law was rational before, it's not rational now. That's a curious thing. Does the meaning of the Constitution change over time? Is it fixed? Does a later amendment change the meaning of an earlier amendment? It's actually a very, very contested question. And how should the 19th Amendment affect the interpretation of the 5th and 14th Amendments? And he says, maybe, one second, Oscar. He says the difference between the sexes have now almost vanished. So again, is this a decision that is pro-women or sort of anti-women? In other words, yes, you might want women to have a minimum wage so they earn more money, but shouldn't women be able to negotiate terms on the same as men? And by the way, this is more of an economics point. Does actually having a minimum wage improve workforce for women? Not really. Do you know why? This makes it more expensive to hire women than to hire men. If there's no minimum wage for men, but there is for women, it's cheaper to hire men. So the effect is probably to have fewer women working hours. It's not a pleasant thought, but it's almost certainly true. Right? Minimum wages, sorry. Minimum wages don't actually help people directly. You might think they do, but they actually decrease wages because you have fewer hours to work. The true minimum wage is 0. That's the real minimum wage. You're not worth working. But that's an economic lesson for another day. Yes.
Is anti-women because if women are just now understanding like working and so on like that, and they agree to this number with limited knowledge because they're not familiar with it, then it's like, oh no, let them negotiate on their own, like they got it, but they're coming from a limited standpoint versus.
So like a contract of adhesion, maybe that they really can't negotiate their wages.
Yeah, like yeah, we're giving them power, but they really don't know what power they could have.
Interesting. Yeah, I think you make a fair point, Chelsea. What I would say that is the belief is that there's not really equal bargaining power, right? How many of you actually went to your boss and said, "Here's what I want to be paid today"? Has that ever happened to anyone in this room? The answer is not yet. You will, right? If you're an attorney, you can negotiate your wages, right? You're allowed to. In fact, I'm not good at it. I don't negotiate anything. When I started South Texas, like, yes, sign me up. My salary hasn't changed much the last 15 years, right? But some people are good at negotiating for wages. But I think to Chelsea's point, if they're just coming out of the kitchen, out of the nursery, they might not even know what to do. Yeah. But the premise, oh, I'm sorry, Oscar, I didn't call on you. I'm sorry. Well, what they're saying is the 19th Amendment affected the 5th Amendment. So the 9th Amendment the 19th Amendment, 1920, all the way back to 1791, right? Time of James Madison, George Washington. I'll make this point. I think there's a very decent claim that the 14th Amendment protects right of contract. I am less convinced the 5th Amendment protects right of contract. That wasn't discussed when the Constitution was adopted. By the 1860s, yes, but not in the 1790s. So I have trouble with Adkins on many levels. All right, let me move along. We're running a little bit short on time. There were 2 dissents in this case. One dissent was by Chief Justice Taft, who again was a former president. You read about him in the case of Myers against the United States. And Taft is like, it's not our job to decide if this legislation is unwise. He is basically echoing Holmes in the Lochner case. He says, I'm not sure how we reconcile with Muller against Oregon. He says the 19th Amendment did not change the strength of women. Right? If women were weak in Muller, they're weak today. The amendment gave women political power. That doesn't change the legal analysis. And even if we want to have sort of equality among the races, that's for the executive branch and the legislative branch, not for the judiciary to do. Then you have Justice Holmes. And he says, look, there's a good fit between the means and the ends. He says this very clearly. The end, to remove deterioration of the race, to promote health and immorality, right? The means, Congress said if women earn more money, they'll be healthier. They'll have more money to eat. Is that so unreasonable that he says we're so many intelligent people say this issue more than we have? Can it really be that this is not a reasonable law? Holmes like, it doesn't really matter, right? The evidence of women and mortality and strength and weakness doesn't matter. If the people who pass this law think it's reasonable, That's where my inquiry concludes. The 19th Amendment did not change anything, Holmes says. That's a holding in. That's the holding in Adkins. Okay. Questions on Adkins? Yes, sir, Bobby.
Okay, so is the argument that like in some cases, you could have a minimum wage that's too high to not be worth the labor, and then at that point, you're seizing.
Oh, of course, yeah. This law may seem like, yeah, it's trying to help women. This actually probably kept women out of the workforce. By making women more expensive to employ, women were employed less. So yes, whatever woman happened to get a job, she perhaps had a higher hourly wage with a few hours available. It's sort of it's just, that's pretty basic economics. Yes, ma'am.
Think that the goal was still to keep the women in the household?
Yeah. It's competition. The same way that Big Bread was trying to keep the little immigrant bakers out of the workforce. This is about keeping women in the workforce. I mean, it's. Oh God, I'm gonna get myself in trouble. Who likes the minimum wage? People with a lot of experience, right? Veterans. Why? Because if you increase the wage, people at the bottom, you increase wages up the way, and it makes it harder to break into the field. It helps them. I mean, I fly a lot, right? Who has the best shifts among pilots and flight attendants? Not the person coming in, it's the most senior people. And they love these seniority regimes. They help people at the top of the ladder. So these laws are not actually helping the people at the bottom, helping people at the top. That this is just basic economics. I'm sorry, I'm sort of veering, but this was that protectionism, right? I mean, why the sick chicken case, right? What you hear Big Bread? How about Big Chicken, right? Who was hurt by the chicken law? It was the smaller chicken people, not the big chicken people. Big chicken people, like thousands of chickens. They pick whichever one's there. It's the smaller butchers that were actually affected by this chicken law. And the reason why these laws were enacted was they had these very well established business owners. Okay, here are the regulations, and FDR said, yeah, we'll approve those. That's how the Fair Labor Codes work. Sorry, you even take economics. It's a good class to take. Maybe you took economics in college. Really? How do you graduate college and take economics? Really? You don't have to take it?
You could take accounting instead.
That's not economics. I take it anyway. All right. What else, Sheldon?
It seems to me that his contradictory to the majority in the first case we read, where the belief is that they aren't a ward of the state and they can make their own contracts. And it seems like creating minimum wage means, well, the state decides what's best for the individual. And if that wasn't considered, like at the founding, that the founders believed that the state was going to decide.
Well, again, in fairness, right? And I always try to be fair. Maybe I don't succeed, but I try. If the people decide that they have an interest in protecting women's negotiating rights, and they intervene, right? And even if the framers thought one thing, it doesn't necessarily mean that's fixed in time forever, right? The question whether the Constitution protects this is somewhat of an open question. It's not clear. So it's not entirely settled that whatever the framers thought, that's the answer here. That if people come together and they like, why is it called progressive? They're making progress, as one might say, right? They're progressing to a different society where there's protections for workers that didn't exist before. All right, so let me wrap up a bit. The cases we have today sort of represent the shift in the tide. The Lochner opinion had these three opinions that were significant. The majority opinion applied a presumption of constitutionality and placed a burden on the government to defend the law. Sure that there was a very close fit between the means and the ends. Justice Harlan applied what we might call a presumption of constitutionality, where the burden was placed on the bakers to show that there was not a good fit between the means and the ends. And Justice Holmes applied an absolute presumption of constitutionality, where the evidence didn't matter much, that the plaintiff was not going to prevail under this due process case. Muller, by contrast, simply said, we're gonna accept the social science from Justice Brandeis, from Judge Brandeis. And we're gonna say that women are inferior and the state has an interest in preserving the ability to reproduce and not be injured. Buchanan said that the state cannot have forcible segregation, violates liberty of contract. And Adkins applied the due process clause of the Fifth Amendment to say that the minimum wage law was a violation of the liberty of contract of women. All right. I think that's it. Anything else? I will see you all on Sunday. Thank you so much.